Mulțumim foarte mult. Dau cuvântul domnului Frédéric Teillet pentru prezentarea domniei sale. Vă rog.
Mulțumesc mult, Laura, și bună ziua tuturor. Sunt magistrat de legătură la Ambasada Franței și încerc să vă expun sistemul francez despre confiscarea, dar din păcate nu vorbesc suficient de bine românește pentru acest tehnic subiect. So I will switch to English, even if I'm not sure that it will be better. French people are like this, or most of them at least. So from the French system, we had an evolution quite important in 2010, and what history learns to us is that we have three prerequisites necessary. We must to have appropriate procedural instruments to be effective. But it's not sufficient. You must have magistrates. Yes. Okay. So you need to have procedural instruments. And you need to have magistrates' readiness to make use of the said instrument. That's like a cultural revolution for French magistrates, and I think for most of European countries. And because magistrates are not the only ones involved in these matters, you must have involvement of all relevant public sector services, investigation services, tax services, and so on. The first step, in my opinion, is to have confiscation before seizure before confiscation, because otherwise the risk is important that the person made bankrupt before to be convicted. But to have a wide seizure, you need to have deep investigation for property to identify the assets. So we created in France, like Romanian Arrow, which is called PIAC, for Plateforme d'Identification des Avoirs Criminels, which is a service located at the central level with several regional offshoots, and which have a wide access to all the databases who can be useful. FICOBA, which is a database with all the bank accounts in France, a data bank with on property, land registry records, and so on. This organization, PIAC, comprises policemen and gendarmes, as well it means investigators, as well as civil servants from other public sectors like customs, tax, etc. So you have 30 people all involved in this matter, and out of which 11 are investigators. That means that all the rest of people from this organization are from all other public services. Of course, it's a part of Karin network, and it works with Romanian arrows, I think, quite well. That's what Cornel Călinescu told me, at least. So before 2010, like in other countries in Europe, only certain goods could be seized. It means that only goods who have a link with the infraction, with the crime, because it's the instrument of the crime, because if it is the object of the crime, or because it's a proceed of the crime. And we could also seize dangerous and harmful goods like arms and drugs. And the law for 2010 was very important because it allows now the confiscation, the seizure of everything that can be confiscated, and as the law allowed also extended confiscation with all the property of the convicted person, so that you can seize every good from the criminal. As I told you, now you can confiscate everything, every good of the criminal. You can, first of all, seize for every crime all the assets who are linked to the crime. That's quite usual, but you can, and it doesn't matter whether it's divided or undivided, whether it's the property of the criminal or whether he disposes freely from this good. All those goods who are linked to the crime can be seized and confiscated. But what is more, for every infraction, for every crime, for which you may be sentenced with less than 5 year imprisonment, you can also confiscate it, every asset belonging to the convicted offender, provided that never the owner could account for the origin of this asset. So it's the equivalent of Romanian extended confiscation, but it's not yet our extended confiscation. It's a confiscation wider than the first one for all the infraction with more than 5 years imprisonment provided by law. And what is our extended confiscation is the confiscation for all the assets, all the property of the convicted person, and it must be provided by the law for a list of infractions that you have now on the screen. And as you can see, it's quite wide, and it's in links with most of infraction with organized crime and high-level corruption. So, seizure in French law is decided whether by the prosecutor, with authorization of a judge, what we call juge des libertés et de la détention, either by the examining magistrate or juge d'instruction. It depends on who is in charge of the case. You can seize the asset, of course, before the trial, and you can also assign the asset to an investigation service, and it's very useful, for example, for cars that you can assign to the police or gendarmerie. And it's even possible to assign these assets to investigation services even before the trial. The only condition is that the good is actually owned by the alleged offender. Sorry. So if the court decided not to condemn the person or an acquittal decision, the equivalent amount of the good or the good itself, if it still seized, will be returned. And if not, if there is a conviction decision, the tribunal of the court will decide the scope of confiscation. It can also decide to confiscate goods that have not been seized previously, and the amount seized will be used in the first place to pay compensation and interest to the victim, and then for the payment of fines. But what was, I think, at least as important as extended confiscation was the creation of a specialized agency, what we call AGRASC, for Agence de Gestion et de Recouvrement des Avoirs Criminels. This agency depends from Ministry of Justice and Ministry of Budget and is led by a magistrate. His purposes are to ensure better management of complex assets, like companies, like business, like ships, so that their value is still important after 2 or 3 years of investigation. The purpose is also to facilitate the seizure and the confiscation by the support provided to the magistrate. I think it's an important key here, because when you have a judge with all his files, with all the stuff he has to deal with, if it's too complicated for him to decide to seize or to confiscate, he won't. I think there is a natural tendency, I speak as a magistrate, sometimes at least, to go to the easier and to the most fast decision. So it's very important that this agency can provide support to the magistrate when they intend to seize or to confiscate an asset. And this agency deals with the sale of all the goods. I try to go shorter. Okay, you have my presentation in your files, but what is important is if there is no convicted decision, a decision of conviction, sorry, the agency can inform the responsible services and the victims that it will return goods to the convicted, to the person, even if convicted or not, in order to ensure payment of claims. So the administration that knows that a certain amount of money will be returned to the person can seize it by administrative procedures. What is important so is that the agency is self-financed, meaning that it retains, in order to cover its administrative costs, a percentage of the funds obtained from the sale of confiscated goods. So it's totally free for the budget of the state. Few figures about 2012, having in mind that the agency was created in 2010, so 2012 was only the second year of full exercise. You have more than at least almost 40,100 assets seized in 2,100 cases, which mean an average of two goods seized by file. The total value of the goods seized in 2012 is 773 million euros. So it's a huge increase regarding to 2011. 4 million were paid to government or public body, and 21 million were returned. The amount of euro paid to the government is quite low because it's an ongoing process. As the agency began its activities in 2011, a lot of procedures are still in continuation. So to conclude, I think now we can say that France has a legislation quite effective, thanks to PIAC and AGRASC mostly. But I think also that magistrates have become increasingly aware of the importance of seizing the proceeds of crime, which is crucial. It's crucial to understand that imprisonment is not enough to dissuade organized crime rings and white-collar large-scale criminality. Offenders have come to accept and deal with the risk of imprisonment, which is little dissuasive effects. To illustrate this previous remark, I think it's enough to mention that seizure and confiscation measures are subject to more appeals than imprisonment sentences. The public authorities should not concern themselves. It's not what I wanted to. Sorry. Yes. The public authorities should not accept that the crime could pay even a little. I think you have to have a strong determination from all the public authorities, and at least human rights, I think, must not be used as a false pretense not to fight organized crime. All this legislation is conform to European legislation, even when it reverses burden of proof, even with extended confiscation. Of course, the protection of private property is a duty for the state, as is efficient fighting against the crime. Thank you very much.
Mulțumim foarte mult, domnule Teillet.